Is there anything in the Constitution that guarantees a right to an abortion? Of course not. Of course not. The founders would have been astounded at such an idea. The idea of a right to abortion in the Constitution is a perversion of the Constitution rooted in precisely the same sort of logic that allowed the Dred Scott decision to go forward. The two worst decisions in the history of the Supreme Court, the Dred Scott decision, which decided that black people were not people under the Constitution of the United States, and the Roe versus Wade decision, which decided that unborn people are not people under the Constitution of the United States. Both of those decisions are bad. Both of those decisions are wrong. And both are rooted in an interpretation of the Constitution called substantive due process. Now, you may think to yourself, that term seems like it is self-defeating. Process and substance are not the same thing. How can you have a substantive due process? Well, what that means is that we don't like the way that the process goes, not the process itself. We don't like that the law that is being applied at all, and therefore we are going to pretend that it is not done through a proper process. So normally what due process of law means is that you have to have, for example, a jury trial for a criminal matter. Or it means that you have to go through a legal process if you are going to remove someone's property from them. It does not mean, however, that the courts have a say on the status of the law itself that is being implemented. So, for example, let's say that there's a law that says that you are not allowed to steal somebody else's car. And then there's you steal somebody else's car, you go through a due process, and we jail you. The courts do not have the ability to say, we don't like the law that says you can't steal somebody else's car, because that is not due process. That doesn't make any sense. The process itself is due. You just don't like the substance of the law. What the court did in Dred Scott is they said, no. We are now going to use the phrase due process to suggest that the substance of the law itself is wrong. And thus, for example, you have to return black former slaves, escaped slaves, back to their masters, which was the ruling in Dred Scott. Or under Roe v. Wade, substantive due process means that you have to go through a due process, by which we mean you have to allow women to have an abortion. There's nothing in the Constitution that suggests all of this. And you can tell that from the language of the Supreme Court cases that are on point on this. First, what happened is that the Supreme Court declared a right to privacy in a case called Griswold versus Connecticut, which was about whether a state could have laws on the books that banned the sale of contraceptives to non-married couples. Now, I think such laws are incredibly stupid. However, there's nothing in the Constitution that guarantees a right against the state with regard to the sale of contraceptives. There's just nothing there. Right? Obviously, the Constitution does not speak on this. The Supreme Court, however, in that case, declared that there was a broad right to privacy created by, quote-unquote, emanations and penumbras from the First, Third, Fourth, Fifth, and Ninth Amendments in Griswold versus Connecticut. And now, even if you believe there is a right to privacy that emanates and creates penumbras, even if you believe that crap, then that right to privacy still would not encompass a very non-private decision to go to a third-party provider to snuff out a third-party human life, which would be the baby's life in this particular case. In Roe, the Supreme Court didn't even bother with the legal analysis. They just said the right to privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action, or as we feel it is, in the 9th Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. This is completely absurd, obviously. The 14th Amendment explicitly guarantees a right to life, not just a right to liberty. So does the 5th Amendment to the Constitution. The 5th Amendment to the Constitution reads in relevant part that no person shall be deprived of life, liberty, or property without due process of law. Well, it seems to me like being deprived of life because two people have met in a room and decided that you should be deprived of life is in fact a deprivation of life without due process of law. That's not a substantive due process argument. That is a due process argument. There's been no defense attorney for the baby. There's been no trial, nothing. Now, the people who are declaring this phantom right to privacy, it is worthy of note that we have now reached a bizarre point in America's constitutional history, where the same people who declare phantom rights to healthcare, phantom rights to abortion, will state openly that there is no right to bear arms, that the right to freedom of religion ought to be dramatically curtailed so that you can only practice religion in your own home if there, and political speech should be curtailed. You shouldn't be able to spend money on elections. Right? The same people who are willing to override virtually every right that is guaranteed in the Constitution of the United States in favor of a centralized top-down government that controls how we live, those same people are finding new rights in the Constitution that never existed before.